Thank you very much, Joy, and thank you everyone for the profound introduction and also for giving us this platform to interact with SMEs in this key and very important topic. So as has been explained, I'll be taking us through the aspects of understanding, drafting, and negotiating contracts. Let me just share my screen. If you're able to see my screen. Joy, are you able to see my screen? All right.
Yes.
Yes, we can.
Thank you very much. So I'll go straight to the issues. So the first issue will be really understanding, drafting, and negotiating contracts. So as entities and even as individuals, we know contracts are very key in terms of commercial enterprise. And as SMEs, the main reason why you've set up your entity is really to carry out business. So a contract really is a covenant or an agreement between two or more competent persons with a lawful consideration. I know there's a lot of legal mouthful over there in terms of competent persons, lawful consideration, but I'll break down those particular aspects. Essentially, it's just a binding agreement between two or more persons. And in this terms, in terms of persons, it also refers to entities. This can be any form in which the organization has been set up, either as a company, either as a sole proprietorship, either as a partnership. So a contract needs to have the following key elements for it to be valid. There's the aspect of the offer, there's the aspect of acceptance, then the second part, there are formalities, then there's also consideration, there's intention to create legal relations, and I'll discuss each of these particular items in detail. So in respect to offer, let's say, for example, you are an SME in the supply of motor vehicles. And what would be the offer in this particular case? A customer has come to your car yard and has seen a vehicle which they like. So in that particular aspect, they'll present, either they or you will present the offer in terms of either of them is interested in purchasing this vehicle at a particular price, of course, and of course they've seen that particular aspect. So that's not enough to form the contract. So there has to be an acceptance by either party. So if the offer came from the seller, the purchaser must express the acceptance. If the offer came from the purchaser, the seller must accept their acceptance. In terms of formalities, there are different types of contracts, and there are going to be different types of formalities in terms of how you deal with this particular aspect. One aspect of key formality is in respect to land transactions. So in Kenya, when dealing with land transactions, any contract, for it to be enforceable, it has to be in writing. So that's what we talk about in terms of formalities. And then the second aspect is consideration. Consideration is simply what is each party get in terms of the contract. Based on the two examples we've talked about, the one for land, the seller is getting money in exchange for the land which is going to the purchaser. The one for car, the seller is getting money in exchange for the car which is going to the purchaser. So there has to be that particular aspect where one party is getting in exchange for the other. Then there's the intention to create legal relations. This basically refers to aspects, because sometimes you get things like heads of terms, commercial terms. These are aspects which are drawn in terms of commercial transactions, where in case you have maybe complicated details, where you want to communicate to the other party the key items. Like for a commercial term, would really set out what the price are, the conditions, the specifications of the products and all that. So that wouldn't really form an intention to create legal relations. But a contract then is in a case where, especially like we've talked about the one for land, you have a situation where then you have an offer which is written. The seller wants to sell the property. The purchaser has accepted to buy the property. Then formalities, there's those ones like in writing and all that. The other formalities are including in respect to how the contract is signed. In Kenya, again, also a key formality to note is that for companies, the mode of signing agreements is set out in the Companies Act, which is basically through either two authorized representatives or one director in the presence of a witness. So that's for a company. In respect to if you're operating a partnership, you'd find partners have the ability to bind the other parties. So those would be the usual aspect consideration we've talked about. This will then be set out in the agreement, and we'll discuss this when we'll get to the aspect of scope and pricing, because pricing is then a key aspect of consideration, then the intention to create a legal relation. Most of the times you'd find in agreements, there's actually a clause that says the parties here intend to create legal binding relation with respect to this agreement, just for the avoidance of doubt, to meet this fourth critical condition. So there are two main types of contracts. You have written contracts and you have oral contracts. So written contracts are simply those contracts which are in written form, and oral contracts are contracts which are not necessarily in written form. As we said from the beginning, a contract is really a binding agreement between two parties. So when two entities, maybe a commercial aspect, is dealing with another, and you make an oral representation to a purchaser or to a buyer, a contract can actually be deemed to have been entered into. The only problem with oral contracts is that they're much harder to prove. That's the reason why most of the times in commercial setting, you'll see contracts are in written form. And beyond that, as I've said, especially in respect to land in Kenya, these ones have to be written. So what are the key clauses that you'll find in a commercial contract? So these are the key clauses that you'll find in a commercial contract. It's important to note that there's no standard form generally of contracts, except in specific sector-specific matters where you find there's an outline of what is supposed to be in a contract. So the key aspects that you need to find in a contract, number one is parties. Who are the parties to this contract? And mostly you have either it's a purchaser or a seller. And background. Background, this one usually you find it's a clause that appears just below the parties clause, and this one usually just sets out the background that the seller owns this type of property, they've agreed with the purchaser to sell this property, and as a result, they are selling this property based on the terms which have been set out. Then now you go into the commercial terms, which is now, as I've mentioned, the scope. Mostly you'd find the scope. Then you'll have the price, sometimes based on the complexity of the agreement. You'll have other aspects, including specification of the contract, specification of the items, mostly being set out specifically. But for a simple basic contract, you'll just have the scope, you'll just have the price, and then you go to warranties and representation, then there's termination, then dispute resolution, and governing law. So warranties and representations, these ones, again, they're not mandatory in every contract, but there are aspects which relate to the other considerations beyond price and considerations which parties are entering into that contract. For example, the example that we used for the car at the beginning of this discussion. So the normal warranties and representations which parties will be making would be like the seller is the valid owner of that property, number one. Number two, that the seller is also has the authority to sell that property. Number three, that the seller, that this property does not have any other legal encumbrance to any other particular party. So which means that the seller is actually free to transfer that property properly to the purchaser. So mostly those are the type of simple warranties and representations that you'll find in contracts. It's important to have these warranties and representation. And there's a minor difference between these two, because for warranties, in a case where you have a warranty, this is a minor, this is really a minor aspect of the property of the contract, which doesn't go to affect what good or service you're getting. And this one, if there's breach by either party, the party who's aggrieved by that breach is entitled to damages and can actually seek to enforce the damages against the other party. But for a representation, this is an aspect that goes to the root of what you're getting. Like we said, the aspect of the vehicle, we said that representation would be that the seller is actually the valid owner of that property. So if at any point before this transaction is concluded, it comes to the realization that the seller is not actually the valid owner of that property, then there will be a breach of that representation, and the other party who's aggrieved would actually have a right to terminate this agreement. So there's dispute resolution and governing law. This one we'll get into them in detail as we proceed. So before we leave this general overview, it's important to note the importance of contracts and the aspects which we are discussing. So courts and dispute resolution bodies ordinarily do not interfere with the terms of a contract and cannot change what parties have agreed on. This is a critical aspect that we need to note in the essence that in a commercial settings, parties are free to engage with each other, of course, within the general limitation of the law, public policy, and all those general considerations. But beyond those considerations, the two parties are free to engage with each other. Once then these parties enter into a contract, they bound themselves to those specific aspects of the contract. And as we've seen in that first point you've mentioned, courts and dispute resolution bodies do not interfere with the terms of the contract and cannot change what the parties have therefore agreed on. So each party who's entering into a contract has to be very careful to be certain as to what exactly they've entered into. Before you put your signature on that agreement, it's important to either read personally and understand what you've put there. If you really don't have the time or the expertise to go through it, it's important to get a legal person to go through it so that you understand what you're entering into, because once you've signed that agreement, you'll be held strictly to those terms that have been set out in that agreement. So there have been a number of decisions which, as I've set out there, emphasizing that point. In terms of there was a case there in terms of Danson versus Johnson, where a court noted that it's not for the court to rewrite a contract for the parties. A court of law cannot rewrite a contract with regard to interest, as the parties are bound by the terms of their contract. So this is basically between the courts, but also in other dispute resolution bodies in terms of arbitration, mediation. The parties who will be listening in terms of any disputes in respect to that contract will not have leeway to change those terms. So if you make a bad commercial deal, that one, the chips will fall where they lie. In essence, you'll actually have to bear the brunt of that bad commercial deal. So it's really, really important to always read the contract, understand what you're signing before you sign it. Because most of the time you see in practice, parties just signing that and say at the end of the day, it could be providing what is supposed to be there. Most of the time that's the case, but it's important to be very careful to read each and every term of that contract to understand what is there. So as we noted at the beginning, this is a very interactive session. At any point, if anyone has a question, they can raise their hand so that we proceed.
There are already some questions in the Q&A box. That's number one. Number two, if I may ask that you move a little bit closer to the microphone. Some people are saying they can't hear you clearly, if possible.
All right.
Thank you. Well done.
Okay, Ribin, maybe you can answer this. Someone is asking, Mr. Ondwari mentioned that the consideration is money, say to pay for a car. I wonder if you can use barter in the consideration.
Yes, I did mention consideration is money, but that's the general consideration. Most of the time, it's just the value that you exchange for each other. So the barter consideration is acceptable and can actually be enforceable in terms of an agreement. So long as there's value which is exchanged for the other aspect, then that will be a good consideration. So money is the common one, but yes, you can do barter in the consideration. There's someone who's guessing they're not getting the sound. I hope now it's much clearer. Then if the contract is binding, meaning something was left out, it cannot be reinstated by the court of law. No, only parties who've entered into the contract can actually sign to include a new term into the contract. There's something called variation of a contract. The parties who entered into that contract can vary that contract to include a term. But if something is left out and the issue goes to dispute resolution, then the body that is attending to that dispute resolution cannot on its own motion include that term in the contract. This is except in cases where, as you'll see when we deal with regulatory aspects, there are some considerations which are mandatorily implied into the contract based on consumer protection consideration and other aspects. But outside those aspects which are mandatorily included in contract by law, then a court will not on its own volition add something which was left out in the contract. That's left for the parties. The parties themselves would have to agree to include that. If a court can also...
I think Ribin, if I may, please carry on with the presentation because I've indicated we will have 15 minutes for questions. So let people keep posting their questions and we will have 15 minutes to answer them once you're done with the presentation. Thank you.
Thank you for the guidance, Joy. So now we'll move to aspect of pricing and scope of the contract. So as we've mentioned, the key element of a contract, pricing is a key element of a contract as it covers consideration. Any contract which is then found to have lacked consideration will not be enforceable. This is a mandatory aspect. There has to be a clear value which is exchanged for between the other parties. So there has to be something moving from the purchaser to the seller. There has to be something moving from the seller to the purchaser. So mostly it's just an aspect of value. As to whether that value is adequate, that is left for the parties. Because if you make a bad business deal, that's on you. The consideration won't fail on the ground that you made a bad commercial deal and priced your goods at either a very high or low position. Whatever you agree on, so long as there's value moving from one party to the other, it will be upheld as the proper consideration. So contract pricing sets out the amount to be paid for the goods or services to be received in respect of the contract. So this is one of those clauses which, as a party entering into a contract or as a party advising on a contract, you have to be very keen on, because it then sets out the price that has to be paid. And so for the person paying this amount, what consideration do you make? For the person paying this amount, you have to actually ensure that you've discussed on your own, you've assessed the goods or the services that you're getting to ensure that your projected estimate shows that the value which you're committing to is good value for what you're receiving. And also the person who's receiving the money should also ensure that whatever they're committing to is good value for the services they're offering or the goods they're selling. Because once you've signed this contract, this is binding. If the other party meets the obligation, you'll then have an obligation to pay that particular amount, regardless of whether you made a good or a bad deal. So it's important to take key note of this clause to ensure that the amount being paid is commensurate with the value of the goods or services to be delivered under the contract. So this clause ordinarily also sets out the time for payment. So most of the time you'd find either payment is upon signing of the agreement or upon delivery. So this aspect ought to be set out in the contract so that it's clear at what point this payment ought to be made. So most contracts you'd find either it's being paid upon signing or upon delivery, or even a mix of both, where you have a percentage which is being paid at the beginning or a percentage which is being paid at the end. The key consideration to take when you're reading your contract before signing, or even when you're drafting it, is those terms in which you agree in terms of payment, you have to be very clear that they've been set out in the contract, because that's what now would be enforceable. There's also the mode of payment. This one will also be set out under this clause. So are you paying in cash? Are you paying in form of a check? Are you paying in form of bank transaction? All those particular aspects. Then, of course, if it's a bank transaction or a check there or cash, there are aspects of account details for the payment. So it's important for all these aspects to be set out so that, especially for the person paying, so that your obligation is very clear. You know how much you're paying, you know when you're paying, you know the mode through which you're paying, and you know the account details through which you ought to make the payments. So the next aspect is the scope of the contract. So scope ordinarily sets out the items covered if it's a contract for the supply of goods. And again, this one depends on the complexity or simple aspect of the transaction. Like we said for the car, you'd say perhaps it's a Mercedes, the year of manufacture, the model, and of course the registration details as have been set out on that aspect. If it's land, you'll then set out the details of that land, the acreage, the location where it's set out, and the details of that land as had been set out in the registration details. So sometimes you have complicated goods and services which have very detailed specifications. Let's say for engineering items that are being imported. It's important to have those clear specifications set out in a contract, but those ones now you set out them in an annex and all that, so that whoever is supplying is clear as to what exactly they're supplying, and whoever is receiving is also clear as to what exactly they're receiving, so that to avoid a situation of a conflict. So a critical part of the contract that needs to be carefully reviewed and understood, as the parties would only be bound by the contract to deliver only that which is set out in the scope and in the manner set out and nothing more. As we've said again, if in case of any dispute, whoever is listening to that dispute does not have leeway to add on or to remove from that contract. So if as a party you are not clear in terms of this scope, then you found out that you had left out a critical component of that aspect. Let's say, for example, you had contracted with a car dealer to deliver a 2014 Mercedes. Then in the agreement, you did not you were not keen to check out what was written out. Then you find they had written a 2010. So when that one is delivered, it's going to be hard for you to say that delivery of the goods that had been contracted to had not been made. So of course, that's a very simple example, but then it's a key aspect. Always ensure in terms when you're entering into a contract, the scope sets out exactly what you need delivered. And also whoever is also selling, also just ensure the scope sets out exactly what you have to deliver to avoid any situation of conflict at the point of delivery. So there are aspects of insurance requirements. So insurance is not mandatory in all types of contracts. However, insurance as a tool is an important aspect as a risk management tool in a contract. Again, every business person knows that business is an aspect of risk and pricing that risk and managing that risk. So it's important to include insurance clauses in terms of as a risk management tool. So it's not mandatory in most contracts. It's an aspect which you have to make that decision. Is the risk in which you're contracting into something which is really beyond your control and can go beyond the aspect which you're able to cover in respect of a default? If then the answer to that is yes, then you might have to consider that in terms of ensuring that risk, and also other considerations to make in terms of ensuring that risk. Of course, it's a premium which you'll have to pay for that risk and the likelihood of the risk happening and all that. So basically, it's a commercial consideration. So generally, in terms of risk management, is that every contract should be drafted in terms of which the risk is managed by the party who is best able to manage that risk, especially like in that contract for goods for delivery of a contract for delivery of goods, mostly ensure that the risks before the goods are delivered are actually covered by the seller who's then delivering the goods. And the risk then transfers to the purchaser upon arrival at the delivery point and meeting the delivery considerations. So insurance is not mandatory, but then it's one of those risk management tools which as commercial entities, you have to make that consideration based on the risk which is in the contract and the liability that is likely to arise in case of a breach, and of course also the projection on the likelihood of that risk happening. So that's in terms of indemnification. Again, this is also an important tool in risk management and in a contract. Not mandatory in all types of contract, but then it's also an important aspect to just secure a party in the event the other party is in breach of any term of the agreement. So when you're doing an indemnity clause in a contract, there's some aspects to consider in terms of making that consideration. So if you are a party giving the indemnity, it's always best to limit this indemnity to a period of time. But if you're a party receiving this indemnity, you want this to be as open as possible. So it depends on where you're sitting. If you're giving, you want this limited to a specific period of time. If you're receiving, you want this not limited. And if the parties are insisting on limiting this, then you insist on a very long period of time. But mostly where the middle ground is usually found arises from the period of the limitation of courses of action. This is a period within which a party can be able to raise a cause of action through through the courts or the dispute resolution mechanisms that have been set out. So this one, in terms of drafting, it really depends on where you're sitting. But then the best practice is always limited to a period of time and to a defined amount. And in terms of the amount, the best practice is usually to limit it to to the consideration amount being paid under that contract, so that if you're the party being paid an amount, if anything goes wrong and you had indemnified it, you just pay them the amount you had received under that contract and you move on. But again, not mandatory, but aspects to be discussed. Liquidated damages, also not mandatory in all types of contracts. It's also an important as a risk management tool in a contract like indemnification and insurance. So parties can agree for either party to pay the other liquidated damages in the event of breach of any terms in the agreement. Now, there's a key element to note and to be very careful about in terms of liquidated damages, because contracts, as I said, are meant to be binding. And in the case of a breach, the party who's aggrieved is only supposed to receive damages to cover the damage which they've received as a result of that breach. Remedies for breach are not there to make you reach beyond your damage, beyond the contract. So this key aspect is important, because when determining the liquidated damages at the point of drafting this clause, then you have to make a reasonable pre-estimate of the damage projected to prevent these damages, liquidated damages, from being deemed as penalties. Because if they are too high, beyond a reasonable estimate of the damage that you're projected to get from there, then they'll be deemed as penalties. If they're deemed as penalties, then they will not be enforceable by a court or any dispute resolution body that is looking at that aspect. So you have to be very careful in terms of using this aspect in as much as it's advantageous. Also, if it's a bit too high and goes beyond that, it can be unenforceable, and it won't be useful to you if then it's not enforceable. So most of the best practice you see as how to manage this aspect is, once the pre-estimate has been set out, usually have the other party agreeing in the contract by a clause which has been drafted, that they agree that the liquidated damages which you've set out there are a reasonable pre-estimate of the loss that you want to cover with respect to that liquidated damages. So that's an important aspect to look at in terms of there. So the third party rights, this is a very important clause in every contract. So a contract is usually enforceable between the parties to that contract. That's as the general provision. So it's always important to even go a step further and include that clause that the benefits, rights, and obligations under the contract are not for the benefit or for the enforcement of any party beyond that. However, there are other methods within which you can govern the formal inclusion of parties to take up the obligation or the benefits under the agreement. These are assignment and novation clauses. So assignment basically is where you're transferring your obligation to a third party. So when you're drafting a contract based on the contract which you're having, you can limit the other party's right to assign or novate the contract to the other party. Novation is different from assignment, because novation is a case where you substitute the party with another party. So novation happens when you want to change both the obligations and the benefits of that agreement. And this one, again, going back to that example that we are talking about. So for example, if you want to just assign the benefits of the agreement, the benefits of this agreement for a sale of a car would be either receiving the car or the money being the purchase price for that car. If you want to assign, if you want to change, to give this to a third party, you can just do an assignment. But as I've said, you can either have this open for a party to be free to assign to any other party. But if you want to specifically deal with the party you've entered into an agreement with, or there are some considerations which you've made in terms of entering into an agreement, like for a purchaser, the considerations which you would be making, let's say you are dealing with the actual dealer for Mercedes, you wouldn't want them to assign these aspects to another party. So you'd have a clause there that they cannot assign to another party without your consent. But then that's in terms of the benefit. Benefits can only be assigned. Where you want obligations to be taken to a third party, that's when you do a novation, where you bring in a third party and is substituted with the existing party. So what are obligations in an agreement for a sale and purchase of a car? The obligations in this case would be the delivery of that car or the actual payment. So in a case where you want to transfer the obligation to a third party, then you do what is called a novation. But all this can be governed in the agreement, and it's important, based on the agreement which you have, if you have key considerations as to the parties you want to deal with, you want to limit that aspect of that assignment or novation. Most of the cases where you see heavy limitation of the assignment or novation is in the banking and financial services sector, because when banks enter into agreements to lend money to a particular party, it's because they've done a financial assessment of that party. And based on that financial assessment is when they determine what money to give. So of course, banks in these cases usually limit the assignment or novation of this agreement to a third party, so that they have to give consent. And the only way they give consent is also making that commercial consideration with that other party to make that assignment or novation. So in terms of third parties, those are the considerations to look around in terms of dealing with. So the key point really is, if you're specific with the person you're dealing with, ensure novation or assignment is limited. If it doesn't matter who you're dealing with, you are just bothered with the goods or services, then it's free. You can have someone else freely transfer that. So there are aspects of suspension and termination of contracts. These are critical. You need them in all types of contracts so that parties are clear at what point is this agreement suspended, at what point can the agreement be terminated. So the usual grounds for suspension and termination, usually either voluntary. Parties can enter into an agreement where they say by 1 month notice, so long as I give you a 1 month notice, you can either suspend or terminate. Parties can also enter into a contract where if there's a breach of the contract or the agreement, give you a notice of that breach. When it's an aspect of a breach, you have to give the other party reasonable time within which to correct that breach before you terminate. There's also aspect of force majeure. This is a critical legal term, but it usually refers to aspects which are beyond the control of parties. And I'm sure most of us had this a lot when the issue of the pandemic came up. So where there are aspects which are beyond the control of the party, there are clauses which can allow parties to suspend the agreement for a certain period of time. And then if the situation is not remedied, it's either terminated for those particular times. And also expiry of time. Parties can agree this agreement is for this period of time. If this period of time expires, then it's terminated. And Joy, I don't know how I'm doing in terms of time. Are we still moving?
You're doing great. Yeah.
Thank you. So I know we've discussed a lot of those aspects in theory, but how do these clauses look like in terms of practical? So we've discussed the aspect of termination, and as I've mentioned, there can be an aspect of voluntary termination. So you'd find a clause reads that simply either party may terminate this agreement by giving 30 days written notice to the other party. As I said, an agreement is what you agree with each other. So if within the context of your agreement, you're comfortable with the other party terminating the agreement, this is called a no-fault termination, then you can have the 30 days written notice, or even any other day which is commensurate with what you're giving. So I haven't given clauses for all that, just set out simple ones to look at. The aspects of governing law, dispute resolution, jurisdiction. So in every contract, it's important contract. As I mentioned again from the beginning, the law gives parties the leeway to decide some of these particular aspects. However, there are some exceptions to this clause in terms of there are some aspects which are mandatorily within specific jurisdictions that you cannot ignore those ones, but beyond those ones, then the law will leave it free for the parties to decide what law to govern that. But then beyond that, this is one of those clauses which either the court or the dispute resolution body can actually vary it in terms of when it looks at where the parties to the contract are actually located, where the service is being offered, and if there are any public policy considerations. So this one is one of those aspects that can be limited, but beyond those ones, parties are free to set out those ones. So it's important to decide on which law you want to govern your contract, but mostly you have also to take into consideration those particular aspects where the parties are located, where the service is being offered, or if there are any public policy considerations with respect to that clause. But generally in a simple agreement, you'll have something like this agreement shall be governed and construed in accordance with the laws of Kenya. This is mostly in contracts in Kenya. So in terms of dispute resolution, again, parties are free to decide the mode of dispute resolution they want to take. This is critical, especially if you want to take alternative dispute resolution measures. You have to expressly set it out in the agreement, because if you don't expressly set it out in the agreement, then if the other party goes to the usual court process, you won't be able to stop them. But if it's been set out in the agreement that the dispute shall be resolved by arbitration, then it has arbitration or the other dispute resolution mechanisms, then that dispute actually has to go through that process first before going through the other processes. So then there's the aspect of jurisdiction. Parties also have some leeway in terms of agreeing the jurisdiction that will be governing that agreement. But again, this one also ties up with the governing law, where you're free to decide this, but sometimes the dispute resolution bodies can interfere with this slightly in the cases where, based on where the parties are located, based on where the service is offered, or any other public policy considerations. So to the last part, this is navigating regulatory issues. So the key regulatory issues that you'll find affecting commercial contracts would really be what we have. This one I'll specifically speak about Kenya, because regulatory issues would then fall under the jurisdiction of the laws that have been set up. So you'd have issues like the Sale of Goods Act. So like in Kenya, the Sale of Goods Act has some implied warranties and conditions that apply to specific types of contracts for sale of goods and services. So this is mostly set out as a public policy considerations to take care in scenarios where parties may actually omit to involve some of these things in the agreement. So they can be implied in the agreement, except of course in situations where parties have expressly excluded that. But with the enactment of the Consumer Protection Act, there are some aspects which, under the warranties and conditions, which you can't exclude. So those ones, again, have to be looked at in terms of that warranty of owning the actual property that you're selling, that warranty of having the authority to sell or deal in that good or services. And also there's an interesting one where if you are aware of the use or condition which the other party was to receive these goods, and that warranty of delivering a good that will meet that service, then you won't be able to legally avoid that. There are also competition laws and restrictions that govern how parties deal, because there's a Competition Authority of Kenya which regulates the competitive nature of the market. So there are aspects which are restricted. They're called restrictive trade practices. So issues like collusion in terms of tendering, issues of price sharing information, issues that essentially limit the aspect of competitive dealing between entities in the market. Those ones would find them restricted. So it's important while going through this particular aspect to ensure that you're not doing anything which substantially will reduce or interfere the competitiveness of the market. Other things that you'd have, you'd find that would come under scrutiny under these competition laws are issues like exclusivity clauses. In Kenya right now, for you to have a properly binding exclusivity clause, you actually have to apply to the Competition Authority for them to review that clause to see whether it affects competition for it to be applicable. Otherwise, without that, then it's prohibited, and it's an offense to do any prohibited competition aspect in terms of those particular aspects. Then there are sector-specific laws. As I mentioned, especially when you're dealing with land, you have to be very careful to look at or have someone look at the specific provisions of land. As I mentioned, contract in respect to land has to be binding. Sorry, it has to be in writing for it to be binding. There are some specific aspects that have been set out in respect to the signing of this agreement, where it has to be signed in the presence of a witness and all that. So these are the general regulatory issues that would affect a general commercial agreement in the market. So that's my substantive presentation. Happy to take any questions which have already been shared.
Thank you very much, Ribin, for the very insightful presentation. We'll quickly move to question and answer session. I I will look, if you go to the Q&A tab. So someone is asking if the contract is binding, meaning something was left out in the contract, it cannot be reinstated by a court of law.
Yes, it cannot be reinstated by a court of law. So if you made a bad deal and you left out a key aspect of your contract, the court of law cannot reinstate that. The only way to reinstate it is to use the leverage of a balanced commercial consideration to get the other party to agree to vary that agreement by including that aspect.
Right. Emma Wanjiru is asking if a court cannot alter the contents of a contract, what if the terms were unconstitutional? For example, say one of the clauses. Oh, wow, I lost that one. Just a minute. Sorry, I've seen it. So if a court cannot alter the contents of a contract, what if the terms were unconstitutional? For example, say one of the clauses includes that. Okay, can you see that, Ribin? I'm losing it when people type in. Yeah, say one of the clauses indicates that you cannot employ people with physical challenges. This amounts to discrimination, and I wondered how this can be addressed.
Yeah, so if you remember the presentation in terms of the key aspect of a consideration, there was that aspect of the formalities. And these formalities now include aspects which have been mandatorily set out in the other laws. Of course, the constitution aspect being one of the mandatorily one. You cannot contract on something which goes against the other mandatory provisions of the law. So that one would fall on the face of it. So in fact, you didn't even be having a contract if that's the basis of your contract. So the realm of contract law has actually been left within that space which the law itself allows parties to agree on. And in terms of commercial aspect, that one it's a wide scope. But then on other aspects, especially things like relating to human rights, employment, and all that, those ones are heavily regulated. Human rights, employment, competition law, consumer protection, all those aspects are heavily regulated, and those ones you cannot go beyond what the law has mandatorily set out.
All right. Griffin Okemo asked, please comment on the terms and conditions, the difference.
Terms and conditions, in practice right now, there's really not much difference in terms of terms and conditions, because these are essentially terms you'd find these are what you've agreed on as the specific aspects of your contract. Conditions mostly are used in terms of they're called, you'd either have condition precedents or condition subsequent to an agreement. So if you have a condition precedent to an agreement, this is a condition which limits the effectiveness of that agreement. And one of the key areas where you find an important condition precedent is in mergers and acquisition. Because in mergers and acquisition, there are competition laws which don't allow parties to take over other businesses without getting the consent of the competition authority. Again, this goes to the aspect of trying to ensure there is no uncompetitive practices in the market. So this type of agreements, what you usually have is you enter into the agreement, but then there's a condition precedent that agreement is only effective subject to you obtaining that approval from the competition authority of Kenya. The other aspect you'd have especially is when maybe you have an exclusivity clause. You can have it there, but then have a condition precedent that agreement is only effective subject to you getting the competition authority approval for that exclusivity clause. So practically in terms of how it's used, there's really not much difference, but technically in terms of legal interpretation, that's how you'd then be able to distinguish those two.
Right. Someone anonymously asked, some SME clients have been convinced to sign a contract by a larger firm on the basis that it is a standard contract for all their suppliers, whereas the practical implementation is slightly different. in case this goes to court and it is clear that what was in the contract is different from how it was being implemented, and the SME argues that the terms have been changed?
No, you see, at the end of the day, it's your responsibility to look at, read, and understand the contract that you are entering into. Because what I can tell you is once you read this agreement, you will have an usually called a single, forget the term, the general term used for the contract, but it's usually a clause which says that this contract is governed only by the terms and conditions set out in this agreement, and any representations outside this contract are not binding to this agreement. So what that then means is whatever you've discussed outside that contract is completely not binding. Only that which is set out in that contract is what is then binding. But I understand that situation, and it's something which we've seen a lot. Of course, then as an advisor, what we usually do in this particular aspect is to explain to the party before they sign what exactly has been set out in that agreement. Then they make that commercial consideration, whether it's worth going on with it or whether it's worth walking away with it. That's now the aspect of the commercial consideration. As a legal advisor, all I can do is advise you the implication. Then as a business person, you make the commercial consideration, because sometimes the commercial considerations are much bigger than the legal aspects which are then coming out of the agreement.
All right, I think I take away from that.
Go 1 second before you go to the next question. Just to pick from what we've been said, there was this very interesting question that we had last year when we organized this training for SMEs in Nigeria, Ghana, Mozambique. And that question is whether the SMEs actually require lawyers to conclude agreements. So as an SME, do you need a lawyer before you can finalize your agreement or sign your agreement? And why do you need one?
Okay, so on that question, it's in Kenya, at least, it depends with the type of agreement. Because if it's an agreement related to land, then that one as a mandatory requirement, you need a lawyer. But on these other commercial contracts, legally, you do not need a lawyer. However, as a practical consideration, it's always important to have a lawyer look at it, because then they're able to go through every clause and look at every aspect and give you the legal interpretation of that, so that you know exactly what you are binding yourself into. So based on the type of contract, in respect to land, as a mandatory aspect, you need to have a lawyer to draft that agreement and deal with it. But in respect to this other agreement, it's encouraged, it's important to reach out to a lawyer to look at that agreement, but it's not a mandatory requirement. Of course, being a lawyer, I'd very much encourage you to reach out to a lawyer to look at that agreement.
All right, I think the takeaway from that is do not sign what you do not understand. So there's another question from Fatma El Mawi. In a land transaction, the acreage and amount payable was mentioned correctly and paid for, or details went through a lawyer. However, lawyer also wrote above attorney for the seller who mentioned a lower acreage. Title documents are out with correct information. Seller now says he intended to sell a lower acreage than mentioned in the title document. The question is not complete, Fatma. Okay.
I see. So the acreage and the amount payable was mentioned correctly and paid for. All details went through a lawyer. However, for the seller, we mentioned a lower acreage. Correct information. Seller now says intending to sell a lower acreage. So I'm not so sure where the power of attorney comes in, because power of attorney is usually to give someone the authority to sign on their behalf. But this is a case that has to be looked at in detail with respect of looking at the documentation and all that. However, if when the agreement was signed, as you say, the details were set out correctly, and the parties who signed that agreement had the authority to sign that agreement, then the aspects in the agreement would actually be held properly, not unless now both parties agree that there was an error and correct that by agreement. But again, this is a case that someone has to look at all the documentation properly, especially that part of the power of attorney. I'm not so clear how that relates to the transaction.
All right. Jotham Mulamba asks, we've seen a number of managers running down businesses, for instance, increasing operation costs and delay in payment of company obligation to the extent the company is not sued for liquidation. This results in huge avoidable legal costs. Can such damages be recovered from individual managers for their actions rather than organizations?
I think we lost Ribin. Ribin, did you get the question?
Yeah, I got the question.
Okay. So please go ahead.
I mean, unfortunately, again, that's something which is seen in the market in a number of cases. I mean, of course, the managers can be held responsible. This is, first of all, based on their terms of employment. Just to be clear what terms of employment that they entered into that employment with, because if you look at those set of facts, clearly there's a general breach of the usual terms of employment. But beyond that, especially based on the different regime, in the Companies Act, you do have the directors having very specific statutory obligations in respect of the company and the shareholders, which if they breach, they can be held accountable. So also aspects where under the partnership and under the Partnership Act. So, but mostly there's much more protection under the Companies Act. So based on the contract of employment with the specific parties, and also based on the regime under which the specific organization has been established, there are bases to cover and be able to hold them accountable for that.
Okay, someone is asking, as a drafter, let's say you included a clause referring the matter to arbitration. How would you avoid such a clause thereafter?
There's no avoiding it. Once you refer the matter to arbitration, if a dispute arises, then it has to go through arbitration first. That's why parties have to be very careful as to the terms which are being entered into the agreement.
All right. Euphrasia is asking, apart from novation and assignment, are there any other circumstances that third-party rights in a contract can be considered?
Yes, there's one additional one which mostly usually seen in financing cases. It's usually called a deed of adherence, where you have an agreement which allows for other parties to sign on, but then there's a deed of adherence which they agree to adhere to those terms which have been entered into by the initial parties, and they're entering into that. So you can have, especially but mostly this you see in financing aspects, but you can also see in other particular aspects. But yeah, there are other situations. Those are the key ones.
Okay, I'll take the last two. One is, if there was a tenancy agreement and the lease was signed as formalities, and the lease expires, but tenant still occupies the premise and does not pay rent for a period of 3 months, after which he expressed the intention to renew the lease, how can the landlord enforce collection of unpaid rent for these 3 months where there's no formal contract?
So land is one of those specific sectors which are heavily regulated. So that particular aspect is regulated in Kenya under the Land Act, which provides specifically where you have an agreement with respect to a right which you hold in land, like the tenancy, and it expires and then it's not renewed, then what you enter into, it converts into a periodic tenancy based on the period within which, the frequency within which you are paying the rent. So the landlord will still be able to claim rent at the amount that was being paid before, but then it becomes a periodic tenancy based on the frequency for which you are paying rent. So that one is specifically under the landlord.
All right. The last question, what are the available, possible and viable opportunities for lawyers whereas there are draft templates all over the internet platforms? Extrapolate these in the advent of ADR for SMEs. Is it not elbowing out lawyers in the fullness of time?
I mean, the generation which we live in, we have to agree that is a more informed generation, and there's much more access to information by everyone. So the opportunities for lawyers will continue to exist, but then they continue to exist in terms of there's much more work which we need to do as lawyers to show the value which we then bring to the table, especially when dealing with businesses. Nowadays, as a corporate commercial lawyer, your duty goes beyond just being able to draft templates and send to the client, because those ones they can get online. You have to show the commercial entities and the business people that you're actually able to understand their business, able to understand the market which they operate, be able to understand actually how they're making money, so that when you are drafting contract or reviewing contracts for them, you're then able to give them specific advice and drafts that are aligned with how they're making money with their industry and all that. So it gives us more lawyers as much more work in terms of understanding our clients, understanding the environment in which they operate, understanding their strategic objectives, understanding how they make money, so that we move beyond the aspect of just giving general advice, but giving them specific advice that adds specific value to their business in terms of making more money and avoiding regulatory issues. That way, then the business people would see what value you're adding to their business and continue engaging your service.